Good morning and welcome. My name is Janet Milkovich, and I am president of the League of Women Voters of Johnson County. We're so happy that you joined us today. The League is a grassroots organization. We are nonpartisan, and we neither support nor oppose candidates or political parties at any level of government. We are fully committed to diversity, equity, and inclusion in both practice and principle. For nearly 71 years, the League of Women Voters of Johnson County has worked to engage and educate voters on vital issues, such as the one we're speaking about today. Let's move on to today's agenda. Here's our plan for today. We'll spend about an hour with our panelists discussing Moore versus Harper, the independent state legislative theory, and the implications for voters in the League. Questions and answers will follow. Please stay with us for our DEI moment and an important membership survey and announcements about how you can participate in democracy in the weeks ahead. We've got a lot to cover this morning. So to help our event run smoothly, please drop your questions in the chat box. Only the panelists will see your questions and comments. Where is the chat box, you may ask? Click on the chat icon in your controls at the bottom of the screen to get the chat box to appear. Second, once the panel discussion begins, we recommend you watch the program in gallery view. You can switch the layout on your screen by clicking View in the top right corner and selecting Gallery. Third, the program will be recorded and posted to our YouTube channel in the next few days. Now, Co-Vice President Connie Taylor, who has worked alongside Dr. Andrea View, put together today's program. I'd like to introduce Connie at this time.
Thank you, Janet. So why should we discuss this topic? I think we've got two League of Women Voters U.S. principles. We have a democratic government depends on the informed and active participation of its citizens. And along with that, we believe that every citizen should be protected in the right to vote. In addition to that, the League of Women Voters of Kansas for their 2023 legislative priorities include supporting legislation that promotes voter participation. So what is Moore versus Harper? I don't know why I have Oklahoma on my mind. So let's give a little background. This case is at the Supreme Court, U.S. Supreme Court, and they heard oral arguments in December 2022. We'll hear a little bit more about what's going on in that area, but the case stems from North Carolina's redistricting process. And with that, the North Carolina Supreme Court struck down the gerrymandered legislative maps as being unconstitutional, violating the state constitution of North Carolina. And state legislators argued that the state courts and the state constitutions are powerless with regard to federal election. And this is known as the independent state legislature theory. So let's meet our guests for this morning. I'd like to welcome our moderator, and I know I'm going to mess up his name again, Dr. Donald Heidermarkel. He's a professor of political science at the University of Kansas. His research and teaching is focused on the representation of group interests in politics and policy, and the dynamics between public opinion, political behavior, and public policy. And now I will turn the program over to you. Thank you.
Thank you, Connie. Good morning to everyone. Today we have three wonderful panelists, and I would like to briefly introduce them, and then we can begin our discussion. Greg Vonamy is an associate professor and department chair at the University of Missouri Kansas City's Department of Political Science and Philosophy. His research interests include voting in elections, state politics and policy, as well as civic engagement. He's a frequent guest of Steve Karaski on Up to Date, the radio show on KCUR. Next is Jo Nichols, the current president of the League of Women Voters in North Carolina. She is a retired elementary school principal. She's held many league positions at the local level, then 5 terms as president of the state league. This is her last year as president of League of Women Voters North Carolina. And then finally, but not last, is Mark Johnson, one of the 3 founding attorneys with Dentons Kansas City Office. He specializes in the First Amendment field, representing media companies and individual reporters. He also teaches First Amendment law at the University of Kansas School of Journalism, as well as election law and campaign finance at the University of Kansas School of Law. Thank you all, and good morning.
Good morning.
So I guess we'll begin with really trying to figure out what this independent state legislature theory is really all about. So whoever wants to jump in first on this, certainly, and the rest of us can sort of fill in any blanks.
Don, I'd be happy to jump in. The independent state legislature theory, at least according to its advocates, originated with the actual writing of the Constitution, because one of the provisions of the Constitution leaves it up to the state legislatures to determine how elections for U.S. Congress and U.S. Senate are conducted in their states. It didn't really become anything of note until 2000, when Chief Justice Rehnquist wrote a short concurrence in the famous Bush versus Gore decision, in which he, for the first time, talked about it. The Supreme Court itself didn't address it until 2015 in a case involving Arizona, and since then it's kind of taken on a life of its own. So that's where it started.
And would anybody else care to sort of fill in the general contours of what this power and authority is supposed to be for state legislators?
Yeah, I agree with Mark. The way I think about it at just a very bare bones level is, there's 2 pieces to it. There's the state legislative piece, and, so all 50 states have their own state legislatures. So it's the Missouri General Assembly on the Missouri side, Kansas General Assembly on the Kansas side. It's in all 50 states as a state legislative piece. The independent piece is, so the state legislatures are independent of what and when. According to this theory, state legislatures are independent largely of their state constitutions and their state courts in the context of federal elections. And according to this theory, that independence in that context is derived from the US Constitution. But that's the controversial part, whether or not that independence is constitutionally valid or not.
Yeah, and it largely depends on an issue called supremacy. And that is, if there's a provision in the US Constitution that is somehow inconsistent with something in a state constitution, then the US Constitution wins out. And so the idea is that if a state constitution, as nearly all the states' constitutions do, give the legislature and other parts of the state government powers to get involved in the electoral process, to the extent it affects federal elections, those provisions of the state constitution are ineffective and cannot be followed. And only the federal constitution provision is followed. It gets complicated, sorry.
No, that sounds good. So has this theory always been out there in our politics and government? Is it some kind of founding principle? And if not, where did it come from?
Well, one of the things that's happened, as I'm sure many of on the program know, is that this idea called originalism. You take the Constitution as it was written in 1787, and anything that we have to deal with in our lives today is controlled by what was happening back then. And the Constitution itself only talks about state legislatures having this power, period. Doesn't say anything more than that. And so all of the things that we know as to how elections are run, you know, the roles of the local election officials, you know, who decides where polling places are going to be and what hours they're going to be open, they have been traditionally controlled by state law and state constitutions. Now, the idea is, well, we've got to go back to what the Constitution said as written in 1787, and it doesn't say anything about anybody other than the state legislature being involved in this process. And so it's originalism, it's textualism, whatever you want to call it. That several of the people on the Supreme Court, Justices Thomas and Gorsuch and Alito, are probably the best examples of the advocates of this, who say we've got to go back to where it was in 1787. If it wasn't, wasn't something we did historically in 1787, we don't do it today.
Okay, thank you.
So Don, my answer to that question would be kind of yes and no. To this, is this something we've always done? The no aspect is no. This has never been done before. State legislatures have always their rules have always been subordinate to state constitutions and state courts from the ratification of the Constitution in 1788 through today. So that answer is no. If the Supreme Court upholds the independent state legislature theory, depending on the manner and context in which they do it, it would mark a legal change in the way state governments function and the way elections function that has never been the case, in American history. So that answer is no. So that this would represent something new. This is not reflective of American state government tradition or election tradition. The yes part is the theory is predicated on part of the original constitutional text. So it's been there since 1788. It's just never functioned in that way. So there's sort of a yes and a no. I think there's something for both advocates of the theory and opponents of the theory to hang on to in terms of American history. The form, so you might, one part of your question might be, why are we addressing this now? Has there been some constitutional amendments, some legal change? No. So the law is the same as it has been since 1788. The question is, are we going to apply it in a different way than we have before?
Well, I guess that kind of brings us right into the North Carolina case and to think about Moore versus Harper in particular. So if maybe Joe Nicholas can fill us in on what are the events leading up to the hearing before the court in December 22? What are the events as you saw them in North Carolina?
Most definitely. How did we get here? Well, first of all, it's a familiar story in North Carolina to begin with. We always have unfair voting maps, a history of gerrymandering, and more and more and more. The last redistricting cycle, which started with Rucho versus Common Cause, in 2010, there were racially gerrymandered maps limiting the political power of Black voters across our state. We sued and won, and they got struck down. Excuse me. Then the lawmakers moved to partisan gerrymandered maps, saying maps were drawn race blind by packing voters of color and Democrats into a couple of state districts. We sued again, taking away the voice of voters. As you know, gerrymandering is when map drawers try to change a district's boundaries to favor or disfavor different groups of voters, whether based on race or political preference. A bipartisan federal court said this is an extreme partisan gerrymandering, and the state appealed to the Supreme Court. In the 2019 Common Cause versus Rucho, the Supreme Court said state courts have power to control partisan gerrymandering and protect voters through state constitutions. Within the 2021 North Carolina redistricting cycle came about. This cycle started August 2021. The North Carolinians came out and asked lawmakers to keep out communities together and demanded fair maps. But yet again, the North Carolina General Assembly did the opposite of that, which we said they ignored. The Southern Coalition for Social Justice took them to state court, just like the United States Supreme Court told us, and sued under the North Carolina Constitution. Because the Southern Coalition and other groups on behalf of North Carolina organizations and voters, we also sued the North Carolina legislative leadership, resulting in a consolidation of 3 plaintiff groups under the name Harper. Now, Rebecca Harper is an individual plaintiff who is part of a group of individual voters who sued because the maps diluted their votes. We won in February 2022. The North Carolina Supreme Court said legislative and congressional maps were unconstitutional under 4 different provisions: Free Elections Clause, the Equal Protection Clause, the Free Speech Clause, and Freedom of Assembly Clause. It was a historic victory here, which has never happened before in North Carolina. The North Carolina Supreme Court noted voters have a constitutional right to free elections, meaning the outcome of elections are not predetermined by lawmakers. Now we have Moore v. Harper in the U.S. Supreme Court. Speaker Tim Moore, the President pro tem, Phil Berger, and the other members of the North Carolina redistricting committees, unhappy with the required changes to their gerrymandered congressional maps, which were ultimately redrawn by a special expert, modifying the maps to be more fair and representative of North Carolina, decided to appeal the case all the way to the nation's highest court under the fringe independent state legislative theory. They argue that no other state body, including the state Supreme Court, has the power to restrict the legislature's ability to set federal voting rules, specifically ones allowing legislators to gerrymander the state. They're asking for absolute power with no checks or balances, potentially creating 2 different election structures, one for federal, one for state and local, which would cause tremendous voter confusion and could result in voter suppression and disenfranchisement. This goes beyond politics. It's about our democracy. And who is involved? Of course, the plaintiffs from the state court action who successfully challenged the maps that were found to be unlawful. Our group of individual voters from North Carolina, the North Carolina League of Conservation Voters, and Common Cause North Carolina. And also you have the North Carolina legislative leadership. And after the North Carolina Supreme Court found the maps enacted were unconstitutional, they used a radical legal theory called the independent state legislature theory to argue the North Carolina Supreme Court violated the federal constitution by finding the congressional map violated the state constitution. So you see what is happening now. In December 22, the U.S. Supreme Court heard the oral arguments as to whether or not the North Carolina Supreme Court violated the federal constitution and if legislative leadership has absolute power. In June of 2023, we hope to hear something. Now, what happens if it doesn't? The theory, if accepted by the U.S. Supreme Court, could also undermine other well-established and critical checks on legislative outreach, including the power of a governor's veto and citizen-led efforts like ballot measures and initiatives. Secretaries of state would be constrained in their ability to develop regulations interpreting state election law. A ruling in favor of North Carolina lawmakers would also invalidate any state constitutional provision that governs federal elections. Further, depending on the scope of a ruling endorsing the ISLT, prior state court rulings, vetoes, and direct democracy efforts that protected voters and access to the ballot would be overturned. Democracy, as we know, in the United States would cease to exist. I can go on and on for more too.
Well, thank you. I mean, one thing that I've noticed here is that that in fact the League of Women Voters in all 50 states have submitted amicus curiae briefs to the Supreme Court to stake out the position of the League against this theory. If one of you could explain what these briefs are and what role they sort of play in judicial decision making writ large.
Well, the Supreme Court, almost like any court, usually likes to hear from as many people as possible on important issues such as this. In this case, there were a total of 69 amicus briefs filed by all sorts of groups. The vast majority of them were filed in opposition to the ISL theory. The brief filed by or on behalf of the 50 state League of Women Voters chapters emphasizes, and by the way, written by truly eminent Supreme Court practitioners, emphasizes the chaos that would be occasioned if the Supreme Court adopts this theory. Now, again, I try to simplify it as best I can, and it's not easy. We have federal elections for president, Congress, and Senate, and then we have tens of thousands, maybe, I don't know, I don't know the number of state and local and county elections. The ISL theory, because it comes from the US Constitution, applies only to the federal elections. Even though the states administer all of these other elections, the brief emphasizes the possibility that the ISL theory, if adopted, would apply only to the federal elections, and all the other state elections it wouldn't apply to. And so you would, in essence, almost immediately create two almost entirely separate electoral processes. And when you think about the whole electoral process, it starts with who gets to vote. What's the process to register to vote? But then it gets down into the nitty-gritty of where's the polling place going to be? What hours is it going to be open? How many people have to be there to operate the polling place? Somebody has to make those decisions. And in the United States today, those decisions are almost entirely made by anybody but the state legislatures. And so if the state legislatures are given sole jurisdiction to run federal elections, then somehow they're going to have to decide where the elections are going to take place. If they're advanced mail-in voting, what are the details of that? And as we all know, the legislatures are completely unqualified to do that. And so the brief that the League of Women Voters chapters filed emphasizes the implications of adopting this theory. Electoral chaos.
Well, if I could, so in theory, that's possible, right? So this would only apply. I saw there's a question in the chat. Does this only apply to election law? Not only does this only apply to election law, it only directly applies to federal elections, right? So it's like what Don, Mark, and Joe have been talking about. We have 500,000 elected officials in the U.S. We only have about 537 federal elected officials. Those are the only ones that it directly applies to. In practice, most elections are administered at the state level. Most states have devolved most of those decisions to the counties. So the practical questions of where your polling places are going to be, the design of the ballots, who's going to count the ballots, that's mostly county level officials. And I don't know if I can stress enough just how much strain local election officials feel in terms of their ability to conduct elections. They don't have, I mean, this is not Google, I mean, they're not sitting on wads of cash who can easily, sort of adapt to these systems. They really struggle to administer elections based on the resources that they have. So if something gets changed for federal elections, it's going to affect all elections. There is just no practical way that state and local officials, even if they wanted to, could conduct a two-tiered system of elections where you have a set of rules for federal elections and a set of rules for state elections. One of the other ways of looking at this is, I assume this is League of Women Voters. I assume we have a lot of poll workers on this call. Poll workers are the frontline election administrators. Overwhelmingly, that's how voters interface, and to the extent that voters interface with any election official at all, it's with a poll worker. Most poll workers are not crack election experts who have studied this stuff for decades. It's the person next door. It's somebody down the street who has 8 hours of training on this stuff. There's just no administrative capacity to do something really complicated like that. So anything that gets decided for federal elections, I would fully anticipate that almost all, if not all, of those standards and rules are also going to affect state and local elections.
Yeah. You know, I also think it's significant that briefs were filed on behalf of state and local election officials. I mean, the state officials, it's usually the Secretary of State. And amicus briefs, amicus is Latin for friend, so friend of the court briefs were filed on behalf of the state and local election officials. They were all against adopting the ISL theory. I think that's a significant point. I mean, one of the basic problems with ISL theory is that it's so simple that it's seductive. It's a one sentence in the U.S. Constitution, as opposed to this, incredibly complex process that we've come up with for running elections in the United States. The problem, of course, is everything is complex, everything is complicated, and to look for simple solutions is simply it's going down a blind alley, and that's where I think that this whole argument would lead us if it's adopted by the Supreme Court.
I agree with you guys, because we had a lot of confusion just with the last elections, and particularly in the 2019 primaries, where we had ballots that were thrown out, because of one little thing that was done wrong on absentee ballots. There was close to 300,000 that were thrown out, weren't even counted within our state. And that sort of, if you go to this, it's amazing. This will be complete chaos.
So just to sort of clarify,
Don, let me interrupt for a second. One of the questions in the chat room talks about ballots, and the ballots we have, as we all know, have both federal and state elections on them. It's quite likely, and we're talking about likelihoods and possibilities and probabilities, that we'll end up with a system where we have two separate ballots. It's I think that's a probable result in a lot of states.
So to follow up related to that, I mean, on the one hand, I'm now imagining that in a state, let's say like Kansas, where I could, for federal elections, I could require a voter ID, but theoretically not require it for, state and local elections. So that I could literally have a person who's allowed to vote in federal elections, but not in non-federal elections. Is that like one outcome that's possible, that we'd actually, beyond having separate ballots, you might actually have to consider separate polling places so as not to confuse voters?
It's a possibility.
Yeah.
And actually, one of the one of the folks also asked, are there Republican secretaries of state who are opposed to the ISL theory? I can tell you that Scott Schwab, who is, as many of y'all know, every bit as conservative as most Kansas politicians, opposes the ISL theory.
So related to that, are you seeing bipartisan opposition to ISL, or is that just the outlier case where you have one member of another party basically opposing this? So is it bipartisan?
Now, if you see a judge, and many of you have gotten to know this judge, Michael Ludig, who is one of the best, well, he's now retired, but one of the best federal judges in the United States. Again, every bit as conservative, Republican appointed, and he testified in the January 6th hearings. Judge Ludig wrote an article in the Atlantic magazine and said that there is absolutely no support to be found anywhere in history or the Constitution for the ISL theory. And he has impeccable Republican credentials. Yes, there are a substantial number, there's a substantial bipartisan opposition to it.
Well, it's worthwhile coming back to this because I understand there were some recent developments in the Scottis case, but have any recent developments led us to believe that the case is likely to be dismissed and that the court has the ability now to dismiss this case without actually addressing the fundamental issues?
Well, yesterday, literally yesterday, the North Carolina Supreme Court granted the state legislature's motion to rehear the case largely on the basis that the partisan majority of the North Carolina Supreme Court changed with the November election. Before that, it was 4-3 Democrat. Now it's 5-2 Republican. The case is going to be heard on March 14th by the North Carolina Supreme Court. There is a possibility that the court will say, hey, our earlier decision was improvident, we withdraw it. And so the appeal that's now pending before the U.S. Supreme Court will become moot. And the court generally looks for excuses not to have to decide cases. But that doesn't mean that the ISL theory is just going to go away. It'll come up again probably in the next election cycle, 2024. So yeah, there's a possibility that the case that Moore versus Harper will become moot and the Supreme Court will dismiss it without reaching a decision.
Yeah, in terms of what's likely to happen, we really won't know until we get a final answer. So the way the Supreme Court decision-making process works is they've already received written briefs. They've already heard oral arguments. The justices will now meet in conference, and notwithstanding any leak that may take place, which is highly unlikely, it's just them. It's just the justices in the room. They'll circulate an opinion, but that'll just be amongst themselves. We really don't have any visibility on that process until they reach a decision. So we won't know. So what would surprise me is if they issued an opinion where they ruled in favor of strong independent state legislature theory. And that's kind of what we've been talking about, right? So if they interpret the Constitution as just saying state legislatures are completely free and unfettered of any state constitutional restraint, I would find that surprising. That would really mark a significant change in elections. It would be a really unusual way of even thinking about the legal arrangement of states. It also, in a sneaky way, kind of puts the U.S. Supreme Court in the crosshairs, because the same U.S. constitutional provision around independent state legislatures theory also allows Congress to regulate federal elections. It says nothing about the Supreme Court, the U.S. Supreme Court, or the U.S. Constitution. So there is kind of this sneaky backdoor argument where you could say to the U.S. Supreme Court, what's good for the goose is good for the gander. If state Supreme Courts can't constrain their state legislatures, you can't constrain Congress. And may, in a sneaky way, resurrect certain aspects of the Voting Rights Act that conservative justices on the Supreme Court don't want resurrected. So I think that's unlikely to happen, both for some political and legal, or practical and legal reasons.
Yeah.
I would see a more moderate, it wouldn't surprise me if there was some sort of more moderate, sort of ambiguous ruling in favor of independent state legislature theory, which recognized in a vague way that state legislatures have a certain amount of greater flexibility in terms of regulating elections than they do in ordinary legal domains. Whether or not that would apply to something like redistricting in North Carolina, how far they would go, that I don't know. But I think some kind of half measure or partial step in this direction is probably the most likely direction. If they don't do that, then I think the next most likely thing is they don't recognize it at all. The least likely outcome, I think, is sort of a full-throated independent state legislatures.
Yeah. One of the chat questions asked if the North Carolina Supreme Court is elected. It is indeed. North Carolina is only one of 7 states that has partisan judicial elections. And so, as happened in November, you can see the partisan composition of the court flip. At the oral arguments on December 22nd, the justices, and this is actually very handy, seem to break down into three categories, 3, 3, and 3. Three of them had already, this is Alito, Gorsuch, and Thomas, had already in earlier decisions, in essence, adopted the ISL theory, spoken favorably for it. There are three in the middle, and that's the Chief Justice Roberts, and then Amy Coney Barrett, Justice Barrett, and Justice Kavanaugh. And then there are the three so-called liberals, Sotomayor, Jackson, and Kagan, who clearly in their questions said, this theory is baloney. So it's the three in the middle that seem to be looking, based on their questions, and it was a long argument, over 3 hours long, seemed to be looking for some sort of middle ground, seemed to be looking for a way to recognize this theory without putting us in the potentially chaotic situation that full out adoption would result in. And in fact, the advocates for the theory in their arguments seem to understand finally that full adoption of the theory would result possibly in chaos. And so they seem to sort of shade their argument more toward the middle, saying that, for example, the normal legislative procedures, the legislature passes a bill, has to be signed by the governor to become law. If it's vetoed, the legislature has to override it. So, and to that extent, and they're agreeing that should be adopted. So to that extent, they're saying it's not completely the legislature that should be involved, but they continue to say that when it comes to reviewing the legislative decision, then the courts, state courts, should not be able to do that. And so they're trying to find somewhere in the middle to make the theory more palatable, but boy, it's like threading a needle. And one thing that we can't forget is that at least the Chief Justice and a couple of other justices are really concerned about the institutional role, the credibility of the Supreme Court. The Dobbs decision has already undermined the credibility of the court in the minds of many Americans. If the Supreme Court adopted this radical theory, then I think it would just undermine the court's credibility even more. And so I think they're trying to find a balance somewhere.
So ironically, I mean, the way you all are describing it, it sounds as though in order for the Supreme Court to recognize this theory either partially or fully, they potentially are giving up power from the judicial branch, not just for state courts, but potentially for federal courts as well. So this seems to me to be a real tension between the balance of power across institutions as well as between levels of government.
That's true. I mean, the Supreme Court has already given up the role of federal courts in partisan gerrymandering cases. That was in the Rucho case in 2019. If the ISL theory is completely adopted, they would in effect be doing the same to the state courts, saying you cannot touch these legislative decisions, even if they're, like in North Carolina, very strong gerrymanders based on partisan reasons.
Yeah. So Don, and to that point, there's one other case, there's one other example list that kind of lurks in the background, and that sort of infused this theory with contemporary energy from the 2000 presidential election. There was a prolonged legal and political dispute in Pennsylvania. It's a battleground state. 2020, the pandemic election, a lot of partisan difference in perception of mail-in ballots. The Pennsylvania legislature tried to set the cutoff date for mail-in ballots. They had to be received on election day in order to count. Anything that came in after election day, that's too late. Those ballots don't count. The political context of this is more Democrats were voting by mail than were Republicans. So that was perceived to be a little bit of a restriction on Democratic votes. The Pennsylvania Supreme Court stepped in and said, no, the way we interpret our state constitution, any ballot postmarked by election day has to be counted. And the Pennsylvania Supreme Court and the legislature went back and forth. I mean, it was like just weeks before the election, and voters did not have clarity on what exactly the rules were governing mail-in ballots for their state. That was sort of the first real question. Would the Supreme Court step in and decide that, right? Would they decide? But ultimately they did not. The US Supreme Court stayed out of it. And the Pennsylvania Supreme Court standard applied, that it was a more permissive standard where any ballot that was postmarked by election day was counted. But fortunately, the outcome of the election did not turn out to hinge on that decision. But that's kind of the stakes that are potentially involved in this, where, something seemingly as small as that in a very close state, in a very close presidential election could kind of prove decisive. And I think sort of in the background, aside from redistricting, which is itself a really important issue, people have in mind, what are going to be the rules and regulations around mail-in voting and other convenience forms of voting going forward.
Yeah, Greg is absolutely right about that. That the Pennsylvania cases in 2020 raised a couple of issues that are a little bit different from the Moore versus Harper case. The first is that there were decisions by the Pennsylvania Secretary of State that were at issue in some of those cases, having to do with counting ballots and the like, and it was in the context of those cases when the U.S. Supreme Court was asked to step in, that Justices Alito and Gorsuch and Thomas, in opinions saying we should decide this right now. The rest of the court said, no, we don't need to decide this right now. But it was in those cases in which those three justices said the ISL theory is something that should be adopted. The second thing about the Pennsylvania cases is that it points out that it's not just decisions by the state courts that could be at issue. It's decisions made by members of the state government executive branch, the Secretary of State, for example. And there's a situation right now here in Kansas that points this up. There's a bill that has been voted out of committee favorably, and it's going to go to the state house floor in the next few weeks, in which the Secretary of State, Kansas Secretary of State, would be given the task of writing rules on the use of drop boxes, which I think it's good legislation. We really should have some clarity on the use of drop boxes. But the thing is, if the ISL theory is adopted, then that kind of legislation would be rendered completely ineffective, because it is by the legislature is in effect giving somebody else the power to determine how votes in federal elections may or may not be counted. So this is the kind of stuff, like I said, even if the North Carolina case is rendered moot, this is going to continue to happen, right now and year after year. And so at some point, the Supreme Court is going to have to step in and decide whether to adopt this theory.
So it sort of begs the question of, if this isn't necessarily going to go away anytime soon, who's behind the push to have the court consider and adopt this ISL theory? Who's the legal process obviously costs quite a bit of money. Who's sort of funding this? Who's pushing for this?
Well, without going partisan, there are two Actually, I have to mention of one party. There is a group called the Republican Redistricting Trust. And then there are two nominally nonpartisan groups, the Federalist Society and a group called ALEC, the American Legislative Exchange Council, something like that. All conservative groups, and they are largely funding this process.
Yeah, I mean, so Joe might have a better immediate lens on the North Carolina case, but I hear Don's question. I see Judy's question in the chat about, sort of deep pocket outside money interests. There's sort of two ways to understand that. Are there any deep pocket outside money interests in this? One is to understand that as economic. Right? I mean, is this some economic thing? Are there corporations behind this? Is there something like that going on? I wouldn't really understand this through an economic lens. It's partisan. There are, Democrats see this as something that would hurt their partisan futures. Republicans see this as something that would hurt Democratic partisan futures and therefore help them. So I would largely understand this as something that is, for the most part, I don't mean to dismiss the sincere legal questions and the sincere legal arguments. I think for some people, there probably is a sincere difference of legal opinion on this. But the real energy behind this is the idea that you can get a little bit of a partisan advantage if elections sort of go one way or another, or they're administered one way or another. Empirically, that's a dubious argument, but it's something that a lot of partisan interests believe. In terms of the expense of the legal process, yeah, I mean, a Supreme Court case is extremely expensive, but to put it in context, we spent $14 billion on our last presidential election. There's a lot of money in electoral politics right now. So in terms of the expense of a legal case, I mean, that's going to be a relatively small share of the enormous amount of money that we've seen sort of flown into our elections and in our campaigns.
Yeah, as Greg said, there is money behind this and behind a certain party here in North Carolina that's really pushing this. And it's going to take away the power of the people, with our elections and stuff. It's going to take away the checks and balances that we need to have within our government and stuff.
Given the sort of forces at play, then, what would you recommend that members of the League of Women Voters can do in the interim while folks wait for a potential decision from the U.S. Supreme Court?
Well, I would definitely say that regardless of the outcome, the residents and the voters and the League members have to continue to engage in this political process at all levels of the government. We had powerful residents speaking during the 21 redistricting cycle that we were demanding transparent process, which we still haven't gotten, and fair maps. And if the ISLT is adopted, the power of the people to direct and reform our society will be more important than ever. So we have to stay involved. The members have to see what's happening in their communities. I see a little comment here. We tried that in Kansas and failed too, Joe. Thank you, Leslie. But we keep on trucking. We can't give up. That's the whole purpose behind the League of Women Voters, is to protect our vote for our people within our states.
So one of the questions that is coming across the chat here is, are there other countries where this sort of legal theory, other constitutional republics where this kind of legal theory has either been applied or discussed, or is this another American exceptionalism example?
I certainly don't know of any. And what I do know of the legal and electoral contexts of other countries, I would find it hard that any other country would have sort of the unique arrangements of courts and systems of electoral administration and federal. I mean, just the fact that America has a federal system, where we have sovereign federal and state governments, is already really unique. and then have our unique system of the way we conduct elections is also really unusual. So there's no other example that I know of. And I kind of suspect that there's probably not another one out there.
Well, I agree with Greg. I'm not aware of any, and a lot of it would simply have to do with the process that had to be applied in writing the Constitution, where essentially the Constitution is a document in which the states give certain powers to, at the time, the newly created federal government. And as a consequence of that, we've had this federalism issue for, the 240 odd years since the Constitution was adopted. So there's no place else in the world that has this situation where the local governments have so much power. It just doesn't exist anywhere else. I mean, I think a point that Dion might give some thought to as to what you can do is try to disabuse legislators and advocates of the ISL theory that it's like inside baseball, that, hey, it's something that only sort of a select few people know about. I think if you make legislators aware of the fact that you are aware of this issue and you feel strongly about it, and you are watching what they're saying about it, will have some effect. Whether it would have had an effect on Derek Schmidt's decision to join in a brief at the Supreme Court advocating for adoption of the ISL theory, I don't know if it would have changed his mind. I know that at heart, he's a politician. He served in the state Senate for 2 terms before he was elected Attorney General. And if there had been a number of people who said, Mr. Attorney General, we think that this ISL theory is dangerous, he might have had second thoughts about joining on that brief. So it's all part of the political process.
So one of the questions is basically this idea of at the state level, then, if we presume that the court would allow this theory to take hold, that presumably then state legislatures, which are granted their authority from state constitutions, could basically overrule the document that actually created them. That's the.
They not only could, they'd have to.
Okay, and then the second part of that is basically, could the legislature then sort of delegate away from it these powers that have been granted to it?
Well, yes, as Greg said earlier, yes and no. Yes, they could, but it would have to be, I believe, to some almost like legislative committee that all it would do is run elections. I don't think they would be allowed to delegate that power to anything outside the legislature.
Well, and so we were encouraged by Connie to disagree with one another before our meeting. So I'm gonna go ahead and disagree with Mark on this. So certain states are what are called non-delegation doctrine states. So certain states have written in their state constitutions a prohibition on their legislatures from delegating legislative authority to subnational or to sub-state units. But in this case, if we're in a world of independent state legislature theory, those fetters are gone. I mean, it's a blank check to state legislatures, and if state legislatures want to kick the can down to whoever they want, I don't know what legally there would be this to stop them. So yeah, I mean, I would say it's all bets are off in terms of, and now it would be up to them how much they wanted to delegate. Nobody could stand in their way if the legislature wanted to take that on themselves. But if they decided we don't want to mess with this, and yes, let's send it to the Secretary of State, the counties, whoever, I don't know what there would be to stop them.
That's true, because if the argue that the court should grant state legislature near absolute power over federal elections, even if they violate the state's constitutions, with no check from state courts, governors, or commissions. They can come in here and deliberately rigged voting maps, as well as bringing Jim Crow voting laws back in. that we have a tremendous amount of problem here. We have to always taken on voter ID. They'll be bringing that back in for another round of fights, rolling back the pro-voter reforms like voting by mail, Sunday voting, souls to the polls. Excuse my language, it's a mess.
Oh, so I would say that, so there is kind of one backstop to this, and that is Congress can still regulate federal elections. So you might say, well, what about stuff like the Voting Rights Act? Would that still apply? Yes, that would still apply. So congressional rules would still apply. Federal rules would still apply. Mostly what's at stake is most state constitutions have something like, it's usually vague, but it's something like, we'll have free and fair elections in the state. Usually it's some form of free and fair elections in the state constitution that will go away, or that would go away in the world of independent state legislature theory.
So would there be anything, if this theory were accepted, then anything that would prevent state legislatures from simply disregarding any kind of voter choice in federal elections and given that the state legislatures historically were the ones that allocated electoral college votes and historically were the ones that selected who got to serve in the U.S. Senate from each state, would we just go back to that system?
I was afraid this is maybe where you were going, Don. So again, no, and maybe. So senators, no, right? So U.S. senators, that's a separate constitutional amendment. So we elect senators, done. So that's not going to change. Presidential electors, so in the world of independent state legislature theory, could an independent state legislature just come in and say, we're going to disregard the outcome of our popular vote and we're going to award presidential electors however we want? In theory, no. And this is where congressional regulation is important. So in 1848, the US Congress set federal election day as the first Tuesday after the first Monday in November. Boom. And everybody, no, like that's the way it is. States can't change that. The way that pertains to presidential elections is we have to choose our presidential electors on that day. Now we're still counting ballots and canvassing results and certifying it and blah, 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 blah. But the idea is that the process is set on that day. So everything else that follows is just a derivation and extension of that process. So a legislature could not step in. So like, let's say a legislature sees the results on, November 18th and says, we don't like them. We're going to set a new slate of electors. No, because election day, that federal rule has passed. So in theory, no. I think that would be vulnerable. And I think it would be vulnerable in this circumstance. A state legislature may pass a rule that says in the event of an indeterminate or challenged election outcome, right? So let's say there are allegations of fraud or misconduct or vote rigging or something. They could say in the event of a question about the election, the state legislature will resolve any election disputes. And then they would likely argue that this is simply a continuation of that process that was conducted in accordance with federal law. So in theory, no, but in practice, I think that's probably vulnerable. And in the world of independent state legislature theory, we may see some significant efforts by state legislatures to do just that.
No, I largely agree with Greg. There's a federal law that requires any sort of dispute resolution process. In other words, if as he said, there's situations where there are questions as to the propriety of the voting process or the like, if the state legislature has passed a law before election day that says that here's the process we're going to follow in deciding this mess. And it could include a provision that says that if we can't tell who won more votes for president than the other candidate, then we'll make the decision. But if they don't have something like that process set in place before election day, then they technically wouldn't be able to do it. It would be a mess. It would be a mess. But that was one of the options discussed in 2000 in Florida. The Florida legislature would step in and award the state's electoral votes to one candidate, regardless of how the vote came out. And that was one of the issues that was presented on January 6th. Which slate of electors from a state would have its votes counted. And as we all know, one side said, well, it's up to the vice president, at his discretion to decide which slate of electors to count. Vice President Pence disagreed with that, but there's nothing that said that he had to disagree with that. I mean, he could have said, no, I'm gonna decide.
So hopefully that the new legislation Congress passed cleared that up at the end of last year, that part with the vice president. But we have one last question, and I think this more broadly is helpful to maybe have members think about things that they can do. But it seems that this particular case and lots of similar cases are coming up in large part because we have legislatures being the ones who do the redistricting in many states. Are there alternative ways to conduct redistricting so that the kind of gerrymandering that the North Carolina case represented is less likely to occur? And should league members focus their attention on those alternative forms of redistricting?
Yeah, so I'll throw out two alternative methods of redistricting. So one is to have, so usually it's conducted by state legislatures fully. So usually state legislatures draw US House districts, and state legislatures usually draw their own legislative districts. One alternative model of doing that is to have state constitutional standards that constrain or direct how state legislatures are to do that. So procedurally, it's the same. It's still a decision made by the state legislature, but it's a constrained decision that they make. Independent state legislature theory would probably get rid of those constitutional constraints and take that alternative off the table. The other alternative is to have some type of bipartisan or nonpartisan redistricting commission have responsibility over redistricting. That's been an increasing trend, so more and more states have been moving in that direction. I don't know, and this is where the details of a Supreme Court decision would really matter, whether or not a thing in this case would affect those independent commissions. It might not. The Supreme Court has already previously upheld redistricting commissions. That's not to say it couldn't reverse itself, as we probably all know they can, but they're usually reluctant to do that. So I think those would probably survive, but that would probably be the main alternative, and is still in many states the main alternative to partisan redistricting.
Yeah, I agree with Greg too. That's what we're trying to get across here in North Carolina, is a redistricting commission that are drawing these maps. So we don't have to use our funds and anything else to sue and get things going. We'd like to be able to use those funds for other things. And we're very gracious to the Southern Coalition for Social Justice. We have to keep an eye out on what's happening with everything. If we can come to the table and establish a commission like this, I think it would be worthwhile. We'll see.
Yeah. Well, I think that, the political reality right now in Kansas is that those types of reforms, it would be it would be impossible to get the legislature to adopt those types of reforms. But we do have a constitutional amendment process that can be used, outside of the legislature. And it seems to me that is the only viable route to get, getting the reforms we're talking about here. Have written into the state constitution either a commission process or I suppose standards to be followed in the redistricting process. The legislature is not going to do it itself. I think that that if the league wants to get involved in something like this, it would probably have to focus on the constitutional amendment process, which was done in Florida, for example. Florida legislature didn't want to, impose those reforms upon itself, and so the Florida voters did it to them in adopting a constitutional amendment that said that redistricting shall not favor one party over another. So those are my thoughts about what the league might think about doing, and it's a long-term process. It would take, I'm sure, several years, but the next redistricting isn't for another 9 years, 8 years, 9 years.